Justice Chandrachud, this being a literary event organized by a newspaper, could we begin with free speech, liberty, and national security?
Yes, of course.
If you take the case of Umar Khalid and Sharjeel Imam, they have been in prison for over 5 years without bail, without even the trial having started. Would you think that the stringent conditions for bail under the Unlawful Activities Prevention Act are fair, just, and reasonable if it leads to such an outcome? And also, could you share the experiences in granting bail to similar cases in the past?
One always has the wisdom of hindsight. But I must tell you at the outset that I was a member of the court just a year ago, and I don't want to be seen to be critical or be passing judgment on colleagues who were a part of my own court when I was a judge of that court. But the issue which you've raised is critical, and therefore I'm not going to duck it, I'm going to take it head on. The problem with many of our national security laws today is that they have turned the basic principles of bail on their head. Our law is governed by a fundamental presumption, the presumption of innocence, which means that every undertrial is presumed to be innocent until there's a judgment of conviction. Second, incarceration of an undertrial before trial cannot be a form of punishment. The reason why you have to have an undertrial in jail before the trial takes place is to ensure that an undertrial who may otherwise flee from custody or who may tamper with evidence is not allowed to do so. So if an undertrial is not likely to flee from custody or tamper with evidence, there's no reason to keep that person inside. Now, what has happened is this, that increasingly, and that's my concern, once national security is raised as a defense by the state, and I was really in a defense, I was in a dissent in the Bhima Koregaon case, which was just mentioned a short while ago. Once national security is mentioned as a defense by the state, does the process of judicial review end? And to my mind, it can't end, because there should be no area of the polity or political or social life which is immune from judicial review. The court is duty-bound to carefully scrutinize whether national security is involved. And second, if it is involved, is the detention of that particular accused proportional? Now let's take the two cases that you mentioned. What is attributed to these two people? First, the first statement which is attributed is that one of those two persons said that, well, we will throttle the chicken's neck, which is, a part of the Northeast. And the second, he said that we will break the country into pieces. Now, the question which we have to ask ourselves, and I'm not sure I have answers, we're all citizens, we are thinking citizens, and I now speak not as a judge, but as a citizen. Does speech, however radical, does speech, however strong, by itself become a form of terrorism? Or is there something which must be added to speech to make it an act of terror? That's the question, I think, which we have to ask. The second, and that's my concern over the judgment of the Supreme Court, the Supreme Court has said that the fact that the trial will not end within a foreseeable period is just one circumstance which has to be borne in mind in deciding whether or not to grant bail. Now, the moment you say that, that really justifies the incarceration of an undertrial for long periods of time.
Justice, isn't justice, right to a speedy trial a fundamental right?
It's a fundamental right. It's a fundamental right under Article 21. And one of the problems of the criminal justice administration in our country is the inability of the prosecution to conclude trials for years and years on an end. Which really means that if you're not concluding a trial for, say, 7 years, and you incarcerate an under trial for 7 years, and there is some possibility that at the end of the 7 years, you'd come to the conclusion that the person was entitled to an acquittal, what happens to the lost 7 years? So therefore, 3 points which I want to make, that even if the defense of national security is raised by the state, it has to be scrutinized carefully. Second, if there is no possibility of a trial ending within a reasonable time, then the fundamental right to a speedy trial and the fundamental right to life must have priority. And third, unless we completely revamp the criminal justice administration, we'll have more and more cases of this sort where people languish in jail. For all the cases which get the headlines in the newspapers, you'll see so many other cases which are lost to society. I dealt with many of these cases, and I believe that in the cases which I dealt with, I gave effect to my fundamental philosophy that unless there is something about this particular offender, namely that the offender will run away from our jurisdiction, or that offender may tamper with evidence, and then you can always impose conditions, because incarceration before the trial takes place should not be a form of punishment. And if you keep people behind bars for 5 and 7 and 10 years before the trial takes place, under trial custody becomes a form of punishment, which is completely turning the law on its head.